Hey, welcome back to the Business News Hour. With us in studio is Sam Kreamer from the Kreamer Law Firm. We're going to be talking about protecting your tuchus. Well, actually, it's your assets, but that's another way of saying it. Welcome, Sam. Good to see you, and Happy New Year, sir.
Thank you. It's always a pleasure to be here.
So this is a piece about, well, we'll let it out, trade secrets and non-competes, right?
It is.
All right, so let's get into this. What is it that businesses misunderstand about perhaps non-competes, just first of all?
A non-compete can take various forms, and one of the most important parts of a non-compete is the scope as well as the description of the prohibited activities. A non-compete essentially is a contract, so therefore you have to also make sure that you comply with all of the elements of a valid existing contract. When a court looks at whether or not it's going to enforce a non-compete agreement, court is basically going to do something of a balancing act. It's going to look at the needs of the employer to be protected, but yet it's also going to look at the needs of the employee to make sure that they are not so restricted that they can't work in any form or fashion. Therefore, a court looks at the geography of the restriction and the time of the restriction. It is always a balancing act, therefore, it's a case-by-case specific situation. For unknown reasons to me, people have been running around saying these non-compete agreements are not enforceable. I can tell you that our law firm has been able to get injunctions, our law firm has been able to get damages to protect the employers from bad acts of former employees. These are enforceable, but they have to be properly drafted.
And when we're talking about the penalties for violating a non-compete agreement, where do they fall? Do they fall against the employee or the people that hire the employee?
The answer is both, because arguably a company that employs an employee who is subject to a non-compete is aiding and abetting in the breach of the contract.
Sure.
So arguably, they are what we call joint tortfeasors, meaning they're both liable for the breach.
And that can get expensive, I would imagine, in some cases.
Talk is cheap until you start talking in court. And as soon as you have to go to court to protect some rights or to pursue an action, it can become very expensive very fast.
Where does this whole idea come from, Sam, that people are talking about these are not enforceable? Have there been cases where the non-compete has been so poorly written or exercised that fails, and then people get the idea that it's not enforceable?
I would say they fall into two categories. One is where these agreements are drafted so badly that they're hard to enforce. These are situations where the scope of the activity that's to be prohibited isn't very clear, or they overreach, or frankly they're misused. For instance, you don't want to try to enforce a non-compete over a receptionist normally. On the other hand, if you've got some top salesperson, that's somebody who could arguably damage your firm's income if they go to a competitor. The other type of problem that occurs with non-competes is they're drafted too well, meaning they prohibit an employee from being employed for 1,000 years anywhere within North America, some type of overreach. Now, one of the things that's applicable in these situations involving non-compete agreements, which is not the same under trade secrets, is that there's a judicial reformation option. And what that means is the courts have said, well, I'll tell you what, we'll look at this contract and try to figure out what are the needs and the rights of the parties. And what we'll do is we'll kind of reform the document and make it enforceable according to XYZ parameters that seem kind of right to us. Now, documents that we have drafted have never been subject to judicial reformation and have been basically enforced as written. But by the same token, it's important to know that what's being protected is a key asset of the company. It's really important because employees have access to all kinds of very critical information. And if they just go off to a competitor and take with them a whole slew of clients or some type of other type of confidential information, it could genuinely hurt the employee. Conversely, the employee still needs to eat. Now, what does that mean? Well, that means that you may have been in the car business before, and now you're going to be in the fast food business. But there's still got to be some kind of way for an employee to either earn an income or be able to survive. Arguably, it may be outside the state of Iowa. So that's why these issues relative to scope and geography and time are so critical to these types of agreements. And again, it's a case-by-case determination. Words matter and drafting matters.
Generally, are non-compete agreements more restrictive the higher up the career ladder a person is in a company?
The answer is yes. They're normally more restrictive at the higher levels. But oftentimes we see at the higher levels, there are severance agreements also. So while you are prohibited from doing A, B, C, or X, Y, Z, it may be that you have a severance agreement that helps cushion the economic blow of that time that you're out of the industry.